I appear for the claimant respondent.
Yes. Yes, please.
Nelly is there now.
The applicant is not present. I think I can see Nelly. Is that
Yes.
Josh? Are you for the applicant?
Nelly.
Can you unmute yourself and announce your appearance, please? You are muted. Can you unmute your mic? Yes.
Respectfully, my lord.
Yes.
I am UN Moses, and my humble appearance is for the defendant, my lord.
Yes, my lord. The case is slated today for ruling, subject to the confidence of the court. We are ready to take same.
This is the ruling of the court.
As court pleases.
As the court pleases.
On 5th July 2022, I made an order. This furnace. Maybe just stop it. On 5th July 2022, I made an order in this suit setting aside the termination of the claimant's employment and further directed the defendant to accord the claimants all rights accruing to them as employees pending the determination of this suit. When the defendant refused to comply with the order, the claimants commenced contempt proceedings against the defendant by first applying via a motion for leave to institute contempt proceedings against two principal officers of the defendant, who are Professor Ibrahim Dantani Ushishi, the Registrar Chief Executive Officer of the defendant, and Mrs. Folake Eweje, the Director of Human Resources Management Department of the defendant. In the ruling I delivered on 10 July 2023, I granted leave to the claimants to institute contempt proceedings against the two principal officers of the defendant. After the ruling, Form 48 was issued on 12 July 2023 and served on Dantani Ushishi and Mrs. Folake Eweje. Then on 13 July 2023, the instant motion seeking this prayer. An order of stay of contempt proceedings of the ruling of this court in suit number NICN MN 80820 between Mr. Charles Berger and another versus National Examinations Council, pending the determination of appeal to the Court of Appeal against the ruling delivered on 10 July 2023 by Honorable Justice O.Y. Anuwe. The prayer sought in the motion is seeking for an order staying the contempt proceedings pending the determination of the defendant's appeal to the Court of Appeal against the ruling delivered on 10 July 2023. I have seen the grounds of the motion and have read affidavit in support of the motion deposed to by Lucky Barnabas Ezekiel, Secretary in the law firm of counsel for the defendant, and the written address in support of the motion. The counter affidavit to oppose the motion on 24 July 2023. The counter affidavit was deposed to by Juliana Ghana, a litigation secretary in the law firm of counsel for the claimant. I have also read the counter affidavit as well as the written address filed in support. Now, the decision. During the hearing of the counsel for the defendant told the court that the motion is for stay of execution of the ruling delivered on 10 July 2023. In his written address, counsel for the defendant had made arguments which support an application for stay of execution. In the ruling delivered on 10 July 2023, I did not make any executory order. I simply gave leave to the claimants to commence contempt proceedings against two principal officers of the defendant. The leave granted to the claimant enabled them to issue and serve Form 48 on Professor Ibrahim Dantani Rushishi and Mrs. Folake Eweje on 12 July 2023 to commence the contempt proceedings. The leave is not one for execution, but to commence contempt proceedings. Thus, the appropriate prayer with respect to the leave granted to the claimants in the ruling of 10 July 2023 is the one the defendant sought in the motion, which is for stay of the contempt proceedings. Accordingly, the issue which is to be considered in this motion is whether the defendant has made out a case to be entitled to be granted an order staying the contempt proceedings. In the affidavit in support of the motion, it was averred that after the ruling of this court on 10 July 2023, the defendant filed a motion in the Court of Appeal for leave to appeal the ruling, and it filed alongside a proposed grant of appeal in the Court of Appeal. It was further averred that proposed notice of the proposed notice of appeal contained arguable points of law, and that an application for leave to appeal is deemed an appeal by the appellate court. It was added that in the event that the appeal succeeds, the outcome will affect the judgment of the court, and any step taken thereto. These are all the material facts that were said in the affidavit in support of the motion. The ruling of this court delivered on 10 July 2023 and the motion filed in the Court of Appeal for leave to appeal are attached to the affidavit, but they were not marked as exhibits. From the averments in the affidavit, the only reasons given by the defendant in the motion for seeking this court to stay the contempt proceedings is the fact that the defendant has filed a motion in the Court of Appeal for leave to appeal against the ruling the ruling granting leave to the claimants to institute contempt proceedings. The defendant, however, failed to tell this court the status of the motion in the Court of Appeal. This court has not been told that the motion has been heard and leave granted to the defendant by the Court of Appeal to appeal. This court is therefore to take it to mean that the said motion for leave to appeal is still pending in the Court of Appeal. Now, by bringing this application, the defendant appears to be abusing the judicial process of this court. The defendant is aware of the position of this court with respect to applications of this nature, seeking stay of proceedings or execution on the ground of a pending application in the Court of Appeal, seeking leave to appeal. I recall, and I can see from the record of this suit, that the defendant had previously filed a motion in this suit on 13 July 2022, seeking orders, staying proceedings in this suit, and also the execution of the ruling of the court delivered on 5th July 2022. In the ruling I delivered in the application on 7th March 2023, the defendant and his counsel were properly educated on the fact that this court does not have the jurisdiction to stay proceedings when an application for leave to appeal is pending in the Court of Appeal. I made this point in that ruling on the basis of the law as laid down in Eze against Okolonji, 1997, where it was held thus: a trial judge has no power to grant an application for stay of proceedings where an application for leave to appeal is pending in the Court of Appeal. Similarly, the Court of Appeal has no power to grant an application for stay of proceedings where an application for leave to appeal is pending in the Supreme Court. In either situation, such power inheres with the appellate court to so order. See also Mobile Oil Nigeria PLC versus Kena Energy Limited 2004, where it was held as follows: all court have inherent power to grant or refuse application for stay of proceedings, except the Supreme Court, which cannot stay its own proceedings. Where there is pending before an appellate court an application for leave to appeal, then the lower court cannot grant an application for stay of proceedings. In such a situation, it is the appellate court that can so order. Having held this position earlier in this suit to the knowledge of the defendant has approached this court again, seeking the same prayer I had earlier clearly told it I lack jurisdiction to make. In addition, I also emphasized it to the defendant in the said ruling the important conditions in Order 64, Rule 14, Sub-Rule 1 of the rules of this court, which an applicant seeking stay of proceedings is required to fulfill in the application before such an order can be made. For the avoidance of doubt, Order 64 Rule 14(1) of the rules of this court provides as follows. Where a matter is ongoing and a party is applying for stay of proceedings pending appeal, the party shall, in the application for stay of proceedings, A. File an application for stay of proceedings pending appeal. B. Pay for the compilation of the records of proceedings for which the party is seeking stay of proceedings. C. Exhibit certified true copies of the record of proceedings for which the party is seeking stay of proceedings pending appeal, and exhibit evidence that there is a valid appeal before the Court of Appeal. D. Exhibit evidence that the appeal has been entered in line with the appropriate rules of the Court of Appeal. And E. Exhibit evidence that the party has been granted leave by the Court of Appeal where leave is required either by law or by the rules of or the practice directions of the Court of Appeal. Now, the defendant is aware from the earlier ruling of 7th March 2023 that these conditions are important to be met in an application seeking stay of proceedings. Yet, the defendant willfully failed in this application to satisfy the requirements of the rules. The defendant failed to comply with the conditions in Order 64 Rule 14(1) of the rules, which will enable this court exercise its discretion in favor of granting the prayer sought by the defendant. Accordingly, assuming this court may assume jurisdiction to grant the defendant's application, the defendant did not satisfy the requirements of the rules for stay of proceedings. In my view, this application, which in itself is lacking in merit, is a deliberate attempt by the defendant to irritate this court and waste the time of the court. I find the motion to constitute an abuse of judicial process and it is dismissed accordingly. Cost of 200,000 naira is awarded in favor of the claimant against the defendant. Ruling is entered accordingly.
Stop, please.
As court pleases.
My lord, we are grateful for the well-considered ruling. Thank you, my lord.
Thank you, my lord.
Thank you.
My lord,
Yes.
in view of the ruling just delivered, we have a pending application motion on notice.
We cannot take that one virtually.
As the court pleases, my lord.
It was adjourned for it's only the ruling we can take virtually.
As the court pleases, my lord.
Take a date. Kenny, where's my diary? Oh, I've seen it. Thank you. May 21st.
As the court pleases.
Please, the host of this meeting should try and mute those people who are making noise. This is a courtroom. It's not a marketplace. How can we be holding virtual sitting and I'm hearing noises, people having conversations? The case is adjourned to 21st May 2024 for hearing of pending application.
As court pleases.
As court pleases.
Case number NSCN/AB/MN/04/2023 between Mr. Samuel Deji Kosaba and Nigerian State Civil Service Commission.
Are the parties present?
Parties absent, my lord.
Appearances. Appearances. Registrar, is there any representation in this matter?
Our Jibril just told me that she's find difficult to join, and I said she
saw
should
her.
join.
I saw her.
And
She appeared briefly.
Shedrack said that he will tell somebody to, because he's going to court. So I don't know whether he has give the link to that person.
Our Jibril is online now. Can you announce your appearance, please? Unmute your mic and then announce your appearance.
Okay.
Yes.
With all
Yes.
is our Jibril. My
Yes.
humble appearance is for the defendant.
For?
Thank you, my lord. For the defendant, my lord.
Thank you.
Thank you, my lord.
Okay, here's the ruling of the court. By notice of preliminary objection filed by the defendant on 10th November 2023, the defendant prayed this court to dismiss this suit for the reason that this court lacks jurisdiction to entertain same. In the grounds of the notice of preliminary objection and the affidavit in support, which was deposed to by Yunusa Yusuf Boso, it was stated that the claimant had earlier filed suit number NICN MN01 2022, which suit was determined in the judgment delivered on 10 July 2023. It was the contention of the defendant that the said suit was between the same parties. There's one black square pen where is it? Leather, like, bring it. The defendant sorry, it was the contention of the defendant that the said suit was between the same parties as in this suit, and although the earlier suit was to challenge the claimant's indefinite suspension from service, this suit, which is to challenge the claimant's dismissal, has the same facts as the previous suit. It was the defendant's contention that this suit is materially the same as the previous suit in terms of parties, subject matter, and issues. For this reason, it was submitted by Learned State Council in the written address in support of the notice of preliminary objection that this instant suit of the claimant is caught up by res judicata. In opposing the preliminary objection, the claimant filed a counter affidavit and a written address on 6 December 2023. It was averred in the counter affidavit, which was deposed to by David Garuba, litigation clerk in the law office of counsel for the claimant, that the case of the claimant in the and that was the considered suit is the dismissal of the claimant, which this court did not make any pronouncement on or determine in the previous suit. In the written address in support of the counter affidavit, Learned Counsel for the claimant invited this court to examine the relief sought in both suits, where it will be seen that suit NICN MN01 2022 was about the indefinite suspension of the claimant, while this instant suit is about the dismissal of the claimant. Counsel also referred this court to a portion of the judgment in suit NICN MN01 2022, where this court held that the case was not about the dismissal of the claimant. In conclusion, counsel argued that this suit is not caught up by res judicata, the decision of the court. There is no dispute on the fact that the claimant had previously filed suit MN01 2022 against the defendant in this court, and that the suit had been determined in the judgment delivered on 10 July 2023. The judgment is Exhibit A of the affidavit in support of the notice of preliminary objection. That is to say, suit NIC MN01 2022 had been determined, and the parties in this suit and those of suit MN01 are the same. The area of dispute in this application is whether the subject matter of the previous suit and the issues determined in that suit are the same with those of the instant suit. I have read the claims sought by the claimant in this suit. Going by the claims, the case of the claimant is about his dismissal from service by the defendant. Thus, the issue which this court will be considering in this suit is the propriety of the claimant's dismissal from service. On the other hand, the claims sought by the claimant in suit NICN MN01 2022 and the facts which he averred to found the claims are with respect to his indefinite suspension by the defendant. From the claims sought by the claimant in suit MN01 2022 and the facts which he pleaded, the subject matter of the suit and the issue raised therein is simply with respect to the indefinite suspension of the claimant by the defendant. I have also seen the judgment which I delivered in the suit. The issue I considered was based on the claims of the claimant, and that was the issue I determined in the suit. In the judgment, I made it clear that the case of the claimant is about the indefinite suspension and not about his dismissal from service. In these words, at pages 7 and 8 of the judgment. Quote, I have seen, however, from the defense of the defendants that the investigation has been concluded and the claimant has been issued a dismissal notification. The dismissal of the claimant is, however, not the case of the claimant in this case. He is not challenging his dismissal in this suit. The defendants too do not have a counterclaim in the suit based on the dismissal. Therefore, no issue or claim has arisen in this suit to warrant this court to consider the propriety of the alleged dismissal of the claimant. That takes me to the submissions in paragraphs 4.3, 4.4, 4.5, 4.6, and 4.7 of the final written address of the claimant, where learned counsel for the claimant made very elaborate arguments on the wrongfulness of the alleged dismissal of the claimant. The submission of the learned counsel in these paragraphs of the written address do not support any aspect of the claimant's case. The case of the claimant is simply on the indefinite suspension and not about his dismissal from service. Unquote. Without a doubt, the subject matter and the issue in suit NICN MN01 2022 is the indefinite suspension of the claimant. The case was not about the dismissal of the claimant, and the claimant's dismissal from service was not considered or determined in the said suit. In this present suit, the claimant brought his claims in respect of his dismissal from service by the defendant, which is a different subject or course of action from the indefinite suspension. Although both causes may have the same or similar facts, both cases may have the same or similar facts to support them. The issues or questions to be considered and determined in this suit are not the same as those applied to the previous suit. In my view, although the parties in this suit and those in suit M9C and MN01 2022 are the same, the subject matter and issues in both cases are not the same. For res judicata to operate, it must be shown that the parties, the issues and subject matter in the previous suit are the same as in the suit in which the plea is raised. All the conditions must coexist to sustain the plea. See Minister of Interior versus Etiosa Local Government, Lagos State, 2023. Musa versus Ogunyale, 2018. Accordingly, I do not find this suit to be caught up by res judicata. Subsequently, this notice of preliminary objection lacks merit and it is dismissed. No order as to cost. Ruling is entered accordingly.
We are most obliged, my lord.
Thank you.
Thank you.
So what next?
Wait.
Just a minute.
My lord, we need a date.
Is that how you
For
ask
the
for a date?
substantive-
My lord, we need a date, just like in the market and you need to buy something.
I'm so sorry,
You
my lord.
need a date. Is that how you ask for an adjournment? Where are we in the matter? Before now, before your
My lord.
preliminary objection, is the case ripe for hearing?
Hello, my lord.
Yes,
Is the case ripe for hearing? Have you filed pleadings?
Yes, my lord.
Pleadings have been completed.
Yes, my lord. Yes, my lord.
There are filed defense and there are filed
Mohammed.
reply. Yes, my lord. There are filed defense and the claimant has filed reply
So we'll take a date for hearing.
for hearing. Yes,
For hearing, my lord. Yes, my lord.
Fifth of June.
5th of June.
Convenient, my lord.
My lord,
Yes.
my lord, Barrister Taidi SN has another two matter. He said that the day that this one will be joined, the other two should join to be adjourned to that day. Urutkai and Ebno Airline. 03, Mina 02,
We are talking
2020.
about the date for this case, Mina 01, and you are bringing other cases. If when the time comes, you give that indication.
Okay,
Mina
Mina.
Escort places,
04
my lord.
2023. I
Yes,
want to adjourn it to 5th of June.
the
And
5th of
counsel
June.
says
Escort
it's
places.
convenient for her. So what
Okay,
are
my
you
lord.
saying?
Yes, my
Okay,
lord.
my lord.
The case is adjourned to 5th June 2024 for hearing.
Escort
Escort
places.
places, my lord.
Case number NSCN/ABJ/209/2022 between Dr. Abayomi Olukayode Gregory and the Governing Council, National Mathematical Center, and others. Lord, party is absent.
Are the parties present?
My lord, with profound respect, Felix Kachi appears for the claimant.
Yes.
Yes, ma'am.
Any appearance for the defendant?
Mr. Ofiku, is he online?
I can see P.A. Bello Jr. Is he in this matter?
No, my lord. No, my lord. This
Okay.
cat, Felix Kachi and Ofiku.
Felix Kachi has announced appearance.
Okay.
Is the other
Remind-
lawyer in court? The other lawyer online?
No, I've not seen my lord.
Okay. Felix Kachi is for the claimant, right?
Yes, my lord.
Yes, my lord.
Thank you. Okay, so this is the ruling of the court.
As please.
As a couple please.
On 23rd January 2024, this court heard 4 applications in this order. 1. The defendant's motion filed on 27th January 2023 seeking for an order staying the execution of the ruling delivered on 13th December 2022. 2. The claimant's motion filed on 17th May 2023 seeking leave to amend the originating processes. 3. The claimant's motion for committal for contempt filed on 30th January 2023. And 4. The defendant's notice of preliminary objection filed on 17th March 2023 challenging the competence of the contempt proceedings. I will determine the applications in the order they were taken above. First, the defendant's motion for stay of execution. By motion on notice filed by the defendant on 27 January 2023, the defendant sought an order staying execution of the ruling delivered on 13 defendant's motion for leave to appeal filed in the Court of Appeal. I have seen the grounds of the motion and I have read both the affidavit in support of the motion deposed to by NF Lawrence Adoyi and the written address in support of the motion. The claimant filed a counter affidavit to oppose the motion on 6 February 2023 together with a written address. The counter affidavit was deposed to by the claimant. I have read the counter affidavit, the written address filed in support, as well as the reply on points of law of the defendants filed on 17th March 2023. It is trite that stay of execution pending appeal is at the discretion of the court. See Okafor against Onaife 2002, Governor Oyo State against Akinyemi 2002. This settled law received statutory backing in Section 7 of the NIC Act 2006, which provision empowers this court to either refuse or grant a stay of execution unconditionally or upon the performance of such conditions as may be imposed in accordance with the rules of court. The conditions imposed by the rules to be satisfied by an applicant in an application for stay of execution pending appeal is contained in Order 64 Rule 13(2) of the NICN Rules 2017. By the provisions of this rule, before an application for stay of execution can be considered by this court, the applicant must satisfy the following requirements or conditions. The applicant must have filed an appeal, paid for and ensured the record of appeal is compiled and transmitted to the Court of Appeal. The appeal must have been entered in the Court of Appeal and that there is a valid appeal before the Court of Appeal. While the appeal is one which requires leave to appeal, the applicant must exhibit evidence of leave granted. Evidence of compliance with these requirements must be exhibited to the application in addition to a certified true copy of the judgment or order the applicant is appealing against. Rule 13(3) of Order 64 categorically provides it is only when the requirements in Rule 13(2) have been complied with that the court can proceed to consider whether I've examined the motion of the defendant in line with the requirements of Order 64 Rule 13(2), but I find that the requirements of Order 64 Rule 13(2) of the rules have not been met by the defendants in this motion, where they sought an order for stay of execution. All that was said in the affidavit in support of the motion is that in the ruling of this court delivered on 13 December 2022, this court granted relief 4 in favour of the claimant, and being dissatisfied with the ruling, the defendants filed a motion in the Court of Appeal on 30th December 2022 seeking leave to appeal against the ruling. The defendants also prepared a proposed notice and grounds of appeal dated 23rd December 2022. The motion for leave to appeal and the proposed notice of appeal are exhibits EF1 and EF2 respectively of the affidavit. The fact that the defendants have a pending motion in the Court of Appeal for leave to appeal is not a reason to grant this application. Although an application for leave to appeal is deemed to be an appeal under Section 30 of the Court of Appeal, it is trite that the mere filing of an appeal does not operate as a stay of execution, nor does it constitute sufficient factor or special circumstance to order a stay of execution. See Ikere Local Government versus Adelusi 2008. By Order 64 Rule 83 This court may be amenable to grant stay of execution pending appeal if satisfied that the appeal has been filed and entered in the court of appeal. Therefore, the fact that the applicants have filed a motion for leave to appeal is not sufficient reason for the grant of the defendant's application for stay of execution. From the averments in the affidavit in support of the motion, it is clear to me that the motion filed in the Court of Appeal has not been heard or granted. That is to say, the defendants have not obtained leave from the Court of Appeal to appeal against the ruling of this court. One of the requirements of the rules of this court in Order 64 Rule 13(2), which this court is to consider in deciding application for stay of execution pending appeal where leave is required to appeal, is that there must be evidence that the leave to appeal has been granted by the Court of Appeal, and the evidence must be exhibited to the application for stay of execution. In this application, the defendants have not shown that the motion has been heard or granted. It implies that the defendants have not obtained leave of the Court of Appeal to appeal the ruling of this court. Accordingly, the defendants are yet to file a proper and valid notice of appeal or compile to transmit record of appeal to the Court of Appeal. Without further waste of time on this application, it is my view that the defendants have not taken any of the steps set out in Order 64 Rule 13(2), which will enable this court exercise its discretion in favour of granting the order sought by the defendants. Consequently, I do not find merit in this motion. It is dismissed. Now to the claimant's motion for amendment. In a motion on notice filed by the claimant on 17 May 2023, the claimant sought the following prayers: an order granting leave to the claimant to amend the complaint, statement of facts, list of documents, and schedule of documents. 2, an order deeming as proper and already filed and served the amended complaint, amended statement of facts, amended list of documents, amended schedule of documents, further and better statement on oath, and further and better verifying affidavit, verifying the proposed amendment as proper. As for and 3, and for such orders as this court may deem fit to make in the circumstance. In support of the motion is an affidavit deposed to by the claimant and a written address. Attached to the affidavit and marked collectively as Exhibit 1 is the proposed amended complaint, proposed amended statement of facts, proposed amended list of documents, and proposed amended schedule of documents. In the affidavit, the claimant explained that he sought to make the amendments in order to bring his pleadings in line with recent developments in his case and to adequately address the reliefs he sought. He also said the amendment will secure substantial justice and settle the controversy between the parties. The defendants opposed the motion via the counter affidavit and written address filed on 14 June 2023. Abdulhamid Nasiru Arua, who deposed to the counter affidavit, averred that the claimant has set up an entirely new claim and reliefs in the proposed amended complaint, statement of facts, and witness statement on oath, which did not arise at the time the claimant instituted this action. It was also stated that the amendment sought by the claimant is not to bring his pleading with recent developments in his case, and that the reliefs pertaining to promotion ruling of 13 December 2022, award of costs and retirement were not part of the claim. The depot that the defendant to be overreached and prejudiced by the grant of the amendment because the defense December 2022. I have read the proposed amended or to be amended by the claimant. It is of fresh claims in the proposed amended complaint and statement of facts. Some of the new facts and claims arose during the pendency of this suit. It is settled law that courts have the inherent powers to allow amendments to originating processes and pleadings of the parties at any stage of the proceedings. See Igwe versus Kalu 2002. In Order 26 Rule 1, 2, and 3 of the rules of this court, the court is given the discretion to allow a party to amend the originating processes or pleadings filed in a suit. Also, the rules permit this court to allow amendment of at any time in the proceedings. This inherent power of this court to allow amendment to originating processes and pleadings of the parties is for the purpose set out in Rule 1 of Order 26, which is to determine the real question or issue between parties and to secure substantial justice or settle the controversy between the parties and related issues. Thus, by the rules of this court, the exercise of the power to allow amendment amendment is to be exercised in favor of doing justice in each particular case. However, the rules have also set out some conditions under which the court may refuse an application for amendment. Order 26 Rule 2 provides as follows. An amendment may be refused where it will A, present a completely different case or cause injustice to the other party, or where the application for amendment is brought mala fide. 2, B, necessitate the hearing of further evidence, especially on appeal. C, do not cure the defects in the procedure sought to be cured, or where it is inconsistent and useless. And D, where it amounts to overreaching the other party or an abuse of court processes. The defendant's complaints in the counter affidavit are that the proposed amendment is that the claimant has set up an entirely new claim and reliefs in the proposed amendment which did not arise at the time the claimant instituted this action, and that the amendment sought by the claimant is not to bring this is not to bring his pleading with recent development in this case. The defendants also complained that they will be overreached and prejudiced by the grant of the amendment. In my examination of the proposed amendment, it is observed that the proposed introductions to the originating processes are related and connected to the case of the claimant in the original originating processes. The original course of action has not been discarded. It is still the main issues in the proposed amendment. The claimant merely introduced new facts and circumstances or developments with respect to his case with the defendants, which came up after he had filed this suit, and then sought new reliefs on the basis of the new developments. The claimant has not changed his course of action, and contrary to the belief of the defendants, he is not presenting a different case in the proposed amendment. Let me add that trial has not commenced in this suit. The defendants will have the opportunity to amend their statement of defense, if so desired, to respond to the new facts or defend the new claims of the claimant in the proposed amendment. Therefore, I do not see how the defendants will be overreached if the amendment is allowed. In my view, the amendment sought to be made to the originating processes is connected substantially to the existing course of action of the claimant, and it will not overreach the defendants or occasion any injustice to the defendants. For this reason, I do not think any of the situations in Rule 2 of Order 26 for refusing amendment apply to the circumstances of this application. It is clear to me that the amendment sought to be made in the originating processes by the claimant is to enable the claimant put before this court the whole facts of his case. To allow the amendment will enable the court be seized of the whole facts of the cases and the dispute of the parties, so that the real issues in dispute can be conclusively determined at once. See Bank of Baroda versus Iyala Bani Company Limited 2002, Nigerian Dynamic Limited versus Dumbai 2002. In my view, the dictates of justice and fair hearing require that I exercise my discretion to allow the amendment. The claimant's prayer for leave to amend the originating process and the accompanying process is granted accordingly. Leave is granted to the claimant to amend the complaint, statement of facts, list of documents, and schedule of documents. The clean copy of the amended complaint, amended statement of facts, amended documents, and amended schedule of documents already filed by the claimant on 17th May 2023 are deemed as properly filed and served. The deeming order sought by the claimant in prayer 2 of the motion include to deem further and better statement on oath and further and better verifying affidavit as properly filed and served. The processes which the claimant sought to leave to amend in prayer 1 did not include further and better statement on oath and further and better verifying affidavit. Since these processes have not been amended by virtue of the order of amendment I have granted, I cannot therefore deem the said further and better statement on oath and further and better verifying affidavit as properly filed and served. Now to the claimant's contempt proceedings. The claimant commenced contempt proceedings in this suit by a notice of consequence of disobedience of court order Form 86 issued on 20th January 2023. The notice was addressed for service on Professor James Oguntuashe, Chairman Governing Council, National Mathematical Center, Abuja; Professor Promise Mebine, Director Chief Executive, National Mathematical Center, Abuja; and Dr. Bernard Festus Azuka, Acting Registrar, National Mathematical Center, Abuja. Also, on 26 January 2023, a notice to show cause why order for committal should not be made for Form 87 was issued for service on Professor James Oguntuashe, Chairman Governing Council, National Mathematical Center, Abuja, Professor Promise Mebine, Director Chief Executive, and Dr. Bernard Azuka, Acting Registrar. In both notices, the claimant alleged non-compliance with the order made by this court on 13 December 2022 and required Professor James Oguntuashe, Professor Promise Mebine, and Dr. Bernard Festus Azuka to show cause why they should not be committed to a correctional center. Form 87 was followed with a motion on notice filed by the claimant on 30 January 2023 seeking an order of committal against first, second, and third defendant for contempt and for disobedience to the order of this honourable court made on 13 December 2022. The motion was supported with an affidavit deposed to by the claimant and a written address. No counter affidavit was filed to oppose the motion for committal, and none of Professor James Oguntuashe, Professor Promise Mebine, and Dr. Bernard Azuka filed any affidavit to show cause. Rather, the defendants filed a notice of preliminary objection to the contempt proceedings. I have seen the said notice of preliminary objection filed on 17 March 2023, to which the claimant filed a counter affidavit on 21 March 2023. The defendants in this action are the Governing Council, National Mathematical Center, the Director General, and Dr. Bernard Festus, Acting Registrar. Other than the third defendant, whose name is mentioned alongside his position or office, first and second defendants are positions or offices or organs of the National Mathematical Center. In other words, the first and second defendants in this suit are not natural persons. It is the offices that were sued and not the natural persons occupying the offices. In these contempt proceedings, the claimant is seeking to commit the actual and natural persons occupying the offices of the first and second defendants for contempt. In a situation of this nature, where the contemnor is not a natural person, but it is intended to commence contempt proceedings against the natural persons who are the principal officers or highly placed officers of the contemnor, the applicant must first seek and obtain leave of the court to proceed in contempt against such principal officers or highly placed officers of the contemnor. See Order 63, Rule 6, NICN Rule 2017. It is after such leave has been obtained that the contempt proceedings can be competently initiated against the natural persons who are principal officers or occupiers of the offices allegedly in contempt. The persons named in Form 86 and Form 87 as the first and second contemnors, and who the claimant seek to be committed for contempt, are not named as defendants in this suit. Since the claimant is interested in proceeding in contempt against the persons who occupy the offices mentioned as the first and second defendants, he must first go through the procedure in Order 63, Rule 6. The claimant, however, proceeded straight away to commence contempt proceedings against Professor James Oguntuashe and Professor Promise Mebine in person by the issuance of Forms 86 and 87 for service on them, without first seeking leave of this court to institute contempt proceedings against them. Not having obtained leave under Order 63, Rule 6 of the rules of this court before commencing the contempt proceedings against Oguntuashe and Mebine renders all the steps and processes taken in the contempt proceedings incompetent. In other words, Form 86, 87, and Form 86, Form 87, and the motion for committal issued or filed by the claimant are incompetent for the failure of the claimant to satisfy the condition precedent to the issuance of the processes. Consequently, Form 86, Form 87, and the motion are struck out. Although the names of the third defendant in the suit is the name. Am I still connected to this Zoom? Can't believe
My lord, we
this.
can hear you.
I hope you are still hearing me.
Yes, my lord, we can hear you.
Okay. Although the name of the third defendant in the suit is the name of a natural person, the contempt proceedings against the third defendant was initiated by the same processes which have now been struck out. Therefore, the contempt proceedings against the third defendant suffers the same fate. Now to the defendant's notice of preliminary objection. In view of the decision of this court striking out the processes in the contempt proceedings, the notice of preliminary objection of the defendants have been overtaken by that event, it is no longer necessary to consider the NPO, and it is accordingly struck out. I make no order as to cost, and ruling is entered accordingly.
As the court pleases, my lord, we are most grateful for the well-considered ruling.
Thank you. So, Mr.
My lord,
Hachi,
my lord, sir.
yes, yes.
I'm sorry, I'm Barrister Peter Ochofiku for the first to third defendants.
Okay.
I am sorry, I am before your learned brother, Justice Court 34, Jadi, and I was up taking my case when the decision came in. I'm sorry, I joined you late, but I heard most part of the ruling. We are grateful.
Okay. Okay. Thank you. All of you will get copies of you for printing and then sign them later. You
As the court pleases.
As God pleases, we are grateful.
okay? This matter is post judgment, right?
No, my lord. The matter is to having taken the pending applications.
It's ongoing.
Yeah, it's
Okay.
ongoing, my lord.
So it's ongoing. So haven't resolved all the pending applications. It's safe to take a date for hearing.
Yes, my lord.
Fifth of June.
Sorry, my room. My lord, on behalf of the claimants, the 5th of June is convenient.
I can't hear.
On behalf of the claimants, my noble lord, the 5th of June is convenient to us.
Mr. Ofiku. I presume the date is convenient.
As the court pleases.
5th of June is convenient for us, my lord.
The case is adjourned to 5th June 2024 for hearing.
As the court pleases. Madam, I'm most grateful.
My lord, 5th of June is convenient. Network.
Okay.
Yeah, thank you, my lord.
Okay. Can you call the next case, please? Mohammed, can you call the next case? Call the next case. Am I connected to? Yes. She, yeah, from connect. I'm waiting. Mohammed, that was a problem. Please, can one of you call the registrar, because I'm waiting for him to call the next case. The registrar cannot keep us waiting.
I've called the case, my lord.
I can't hear you. You muted yourself when you were calling the case.
Okay, my lord, NSN/ABJ/183/2023 between Dr. Anthony C. Ude and Midviation 8 Limited and others.
Yeah, yes.
Parties are absent.
Appearances. Is there any representation in the matter?
Yes, I informed them, Jessica, for the claimant, and it's only defendant I can't get there.
Yes, there's only the claimant that was represented from the beginning.
Yes.
No appearance.
Jessica
Michael, Gloria Odo. I can't hear you. Can you hear her?
I can't hear her, man.
You need to unmute your mic. Doesn't even look like her mic is unmuted. Is this Gloria Odo? Okay, this is the ruling of the court.
Ask her places, madam.
The claimant filed a complaint on the 12th July 2023, and he sought the following claims from the court against the defendant. The claims are listed from number 1 to number 18, and I will skip reading them out for sake of time. And I'll proceed. The originating complaint was filed along with a statement of facts, witness statement on oath, list of witnesses, and list and copies of documents. On the same date of filing the suit, the claimant filed a motion on notice where he sought an order entering judgment in his favor and granting the reliefs he sought in the complaint. The motion, which was brought under Order 16, Rule 1 and Order 17, Rule 1 of the Rules of Court, was supported with an affidavit and a written address. The originating processes and the motion were served on the defendants, but only the third defendant filed a memorandum of appearance and statement of defense. Hearing notices were also served on the defendants, and when the defendants did not appear in court on 28 February 2024, the claimant's motion was heard and adjourned for ruling. I have read the affidavit and the written address filed in support of the motion. The claimant brought the motion under the summary judgment proceedings in order 16 of the rules of this court and sought an order to enter judgment as per his claims. I have seen that reliefs 1 to 6 sought by the claimant are declaratory reliefs. All other claims sought by the claimant from relief 7 to 17 are dependent on the success of the declaratory reliefs sought by the claimant. The claims sought by the claimant require oral evidence to be adduced to prove or establish them to the satisfaction of the court. See Maja versus Samoris 2002, Ogolo against Ogolo 2006, Arrow versus Lagos Island Local Government Council 2002. Thus, the declaratory claim sought by the claimant cannot be granted on summary judgment proceedings. Again, summary judgment proceedings is appropriate for liquidated money demands where the claimant believes there is no defence to the claim. See Order 16 Rule 1. I have read the statement of facts, and going by the claim sought by the claimant, the case of the claimant is not for a liquidated money demand, but for claims which, in my view, are undermined. Such an action cannot be brought under the summary judgment procedure. See Chevron Nigeria Limited versus Gori North Local Government Council 2003. Although the second defendants have not filed a first and second defendants have not filed a defence to the suit, and none of the defendants filed a counter affidavit and written address to the application for summary judgment as required in Order 16 Rule 4, I do not think the application of the claimant should be granted in view of the nature of his case. It is my view that the applicable procedure to adopt in the circumstance of this suit is that in Order 38 Rule 2, which requires the claimant to proceed to prove his case where the defendant fails to appear or file a defence. I've clearly captured the provision of Order 38 Rule 2. Accordingly, the proper thing to do in respect of the claimant's motion for summary judgment is to refuse the motion and require the claimant to call evidence to prove his claims. In that regard, the motion is hereby dismissed. The court shall adjourn the suit for hearing. The court further makes an order for accelerated hearing of the suit. Ruling is entered accordingly.
As complices.
So, in respect of this one, we'll take although you want a date for hearing, right?
Don't talk. Self-national.
Do you want to come back on the 5th of June?
Yes, my lord. Yes. She don't answer. Say yes, my lord. Let's say I won't get problem.
The case is adjourned to 5th June 2024 for hearing.
Ask places. Case number NS/Abuja/220/2022 between Comrade Sunday O. Omezi and others, and Nigeria Union of Pensioners, NUPENC. Lord, parties absent.
Okay.
Parties are absent, my lord.
Okay. Appearances.
Yeah, with the greatest humility to my lord,
Yes.
Ade Olusalako, appearing with Miss Malane friend, Michael Ayuba. My lord, we humbly announce appearance for the claimants, my lord. Thank you, my lord.
Thank you. Yes.
Yes, this one too can't talk.
Yes.
Bello the Junior is online.
For the defendants.
Yes, my lord.
So I'll proceed to deliver the judgment.
Ask
It's
up, please.
a bit lengthy, so I'm going to paraphrase as much as possible. This is the judgment of the court.
Ask up, places.
In a complaint filed by the claimants on 19 July 2022, the claimants, who are members of the First Defendants Federal Civil Service Pensioners Branch, sought the following reliefs. The reliefs are listed as from numbers 1 to 11, and I will skip reading them out. And then I will also skip ruling out some other I will skip some summary of facts. In proving this claim, two of the claimants gave evidence. CW1 is Elder Christian EJ Azuna. The second claimant, while CW2 is Comrade Sunday Omezi, the first claimant. The first defendant filed a statement of defense and called one witness. The witness is one Comrade Bumi Ogunkolade. The second defendant was served the originating processes in this suit, but he did not enter appearance nor file a statement of defense. It was also not represented throughout the suit. As a result of its non-appearance to cross-examine witnesses called by the claimants and the first defendant, despite several hearing notices served on the second defendant was foreclosed from cross-examining the witnesses on 19/10/2023. The second defendant was also not present in court on 22nd November 2023 to open its defense in the suit, despite the fact that it was served a hearing notice on 20th November 2023. For this reason, the second defendant was foreclosed from defending the action. Now, there's a ruling on the motion filed by the 6th, 7th, and 9th claimants. I'll take that first. During the trial of the suit, an application was brought by the 6th, 7th, and 9th claimants on 6 June 2023 seeking an order striking out their names from the suit. The motion was heard on 24th January 2024, which was on the same day final written addresses were adopted, and ruling on the motion was reserved to be given with the judgment in the suit. I will now rule on the motion before proceeding to consider the suit. The affidavit in support of the motion was deposed to by the sixth claimant, who said he had the consent of the 7th and 9th claimants to depose to the affidavit. He said the applicants are members of the FCSPB of the first defendant, and he was a member of the NEC whose tenure expired on 18 July 2022. He further said they were not consulted before their names were included as claimants, and they did not consent to be joined as parties in the suit. Accordingly, they dissociate themselves from the suit. The deponent further exhibited letters written by the 7th and 9th claimants to the first defendant, dissociating themselves from the suit. The letters are exhibits A and B. The claimant filed a counter affidavit and written address on 13th July 2023 to oppose the motion. The counter affidavit was deposed to by the first claimant. The gist and effect of the counter affidavit is that this court should refuse the application. Going by the motion, the applicants, who are named as 6th, 7th, and 9th claimants in this suit, do not want to be parties to the suit. They claim not to have been involved in the decision to institute the suit in the first place. It is normal for a claimant who filed a suit to decide to withdraw the suit. So also is the right of any claimant in a suit to decide to withdraw from the suit. Although the claimants dispute the propriety of the application and the reasons on which it is based, I cannot, however, fathom why the claimants will insist that the applicants continue to be retained as claimants when obviously they do not want to continue to be parties to the suit. The applicants and the other claimants are all members of the FCSPB, and this suit is brought for the claimants and all other members of the FCSPB not named in the suit. Therefore, the suit can be maintained without the presence of the applicants in the suit. I cannot see what damage the striking out of the applicants from the suit will cause to the case of the claimants, since the striking out of the names of the applicants will not put an end to the suit. The fact is that the applicants do not want to be parties to the suit. They have the right to so decide. Thus, the court is inclined to grant the application. Accordingly, the 6th, 7th, and 9th claimants are struck out from the suit. I will now examine the suit, and that takes me to the summary of facts, which I will skip. I will also the summary of facts and addresses, and I'll go straight to the decision part of this judgment. In paragraph 36 of the statement of defense, the first defendant pleaded that the suit is incompetent as the claimants failed to comply with the provision of Rule 26 of the Constitution, which provides for internal conflict resolution mechanism before an action is commenced against the first defendant. In reply to this averment, the claimants pleaded in paragraph 41 of the reply to the statement of defense that the claimants exhausted the constitutional internal conflict resolution mechanism in different forms before resorting to this instant action. The constitution of the first defendant is Exhibit C20. Rule 26 provides that any aggrieved member of the union, before institution of legal action against the union, either at local, state, sectoral, or national levels, must follow and exhaust this procedure. 1. Make a formal complaint to the state/sectoral administrative committee for redress, and if the grievance was not addressed by SAC, make a complaint to the state sectoral executive (SEC), and if the member is not satisfied with the decision of SEC, 3. Make a complaint to the state sectoral council (SC), and if dissatisfied with the decision of SC, 4. Make a complaint to National Administrative Committee (NAC), and if not satisfied with NAC, 5. Forward the complaint to National Executive Council (NEC). If not satisfied with the NEC, that's 6, the NEC decision, the member is permitted to then institute action in court. The claimants are members of the first defendant, and as such, they are bound by the provisions of the Constitution of the Union they voluntarily joined. The dispute upon which the claimants have instituted this suit is about non-remittance of accurate check-off dues to FCSPB by the first defendant and the dissolution of NEC of FCSPB by the first defendant. Thus, being aggrieved about these actions of the first defendant, it is such grievances Rule 26 of the Constitution has laid down internal procedure for its resolution before resorting to court action. When the first defendant averred that the claimant did not exhaust the procedure before instituting the suit, the burden shifted to the claimants to prove that they did before bringing the suit. What the claimants said is that they exhausted the internal conflict resolution in different forms before bringing this action. Before this suit, there are letters in Exhibit C21, C22, C24, C25, C26A, C27A, and C27B, written by the second claimant to the National Secretary of the first defendant, complaining severally about inaccurate remittances of 55% check-off dues to the FCSPB. The National Secretary of the first defendant is a principal officer and the chief executive of the union. See Rule 8B and Rule 9(6)A of the Union Constitution. In Rule 9(6)D, the duties of the National Secretary including attending to all correspondences addressed to him, include attending to all correspondences addressed to him. When the National Secretary received Exhibit C21, dated 16th October 2018, it was clear to him that a complaint of inaccurate payment of check-off dues had been made by the FCSPB. By his duties, having received the complaints of the claimants in the mentioned letters, it is the duty of the National Secretary to attend to it by directing it to the first level in the dispute resolution process for resolution. If the claimant's complaint did not get to be attended to by the necessary organs of the union, it cannot be said that the claimants did not attempt to comply with the
Repeat us
procedure
now.
for internal dispute
Repeat us
resolution.
because if they
The
come.
failure of please can you mute your mic? I'm reading a judgment. The failure of the National Secretary of the Union to direct the complaint to the SAC as the
Make I
first
stop.
level in the
Thank you.
process
My
caused
friend,
the
one
dispute.
water. Now make I enter motor come.
Please, can somebody tell that person to mute his or her mic? The failure of the National Secretary of the Union to direct the complaint to the SAC as the first level in the process caused the dispute resolution channels not to be activated. The claimants cannot be penalized for it. They have done what is necessary by formally complaining to the union in several letters. It was when there was no headway that they brought this suit. In my view, the claimants took steps to have their grievance attended to through the internal dispute resolution procedure of the union, but the union failed to attend to it through the procedure it set up to hear such grievances. The claimants cannot therefore be blamed for instituting this suit at the time they did. In the result, the fact that the internal dispute resolution mechanism in the union constitution was not exhausted before the claimants brought this action was not the fault of the claimants, and it does not therefore affect the competence of this suit. I so hold. The main complaint of the claimant in this suit is with respect to payment of FCSPB's share of check-off dues received by the first defendant. Reliefs 1, 2, 4, 5, 7, 9, and 10 sought by the claimants are premised on this aspect of the case. Before I consider this aspect of this case of the claimant, it is necessary to understand some basic facts in the case which will assist in the resolution of the issue. The claimants averred that the first defendant is a trade union established on August 15, 1978 as a trade union of pensioners in Nigeria. The certificate of registration of the first defendant is Exhibit C1. The constitution of the union is Exhibit C20. Let me add that the first defendant is one of the restructured trade unions under Part B of the third schedule of the Trade Unions Act, and its jurisdictional scope cover all pensioners from the civil service of the federation, including local government, statutory corporations, government-owned companies, educational institutions for which the government of the federation is responsible, and all such similar establishments and private sector pensioners. See also the membership of the first defendant in Rule 3.1 of the Constitution of the first defendant, which is Exhibit C20. Without a doubt, the first defendant is a registered trade union to which all pensioners from the federal civil service, state and local government and private sector are entitled to belong. The claimant said they are all retired civil servants and members of the FCSPB. They also said the FCSPB is a sectoral council of the first defendant to which all retirees from the federal civil service belong. In paragraphs 6 and 17 of the first defendant statement of defense, it was pleaded that the pure federal civil service pensioners was part of state sectoral unit of the first defendant, but in 2018 the pure federal civil service pensioners were carved out of the state sectoral unit and made a separate branch of the first defendant. It was also averred that the FCSPB is one of the sectoral units of the first defendant. DW1 also said all this in his evidence. It is therefore not in dispute in this case that the FCSPB is a recognized sectoral unit or branch of the first defendant union, and the branch membership is pensioners from federal civil service, who the first defendant described as a pure federal civil service pensioners. From the case of the claimants, the dispute arose from distribution of check-off dues of members of the first defendant union received by the union from second defendant. The evidence adduced before me in this suit disclosed that the second defendant is responsible for payment of monthly pension to civil service pensioners receiving pension from the federal government, and it makes deduction of check-off dues from the pension of members of the first defendant, which it remits to the first defendant. According to the claimants, the principal source of funding for the first defendant is the check-off dues made up of 1% of monthly pension of every member of the first defendant. The check of dues received by the first defendant is to be disbursed in the following manner as prescribed in Rule 19(7) of the first defendant's constitution. 35% is to be retained by the National Secretariat of First Defendant, 25% to local branches, 30% to state/sectoral councils and the Nigeria Labour Congress. The claimant said for the fact that the FCSPB is both a local branch and state sectoral council of the first defendant, it is entitled to 55% of the check-off dues, which is the 25% for local branch and 30% for state/sectoral council. The claimants aver that from the month of August 2018, the first defendant did not remit its share of 55% check-off dues to it, but was only remitting 27.5% of the check-off dues to FCSPB. The claimants alleged that the first defendant had been appropriating 27.5% of the 55% of check-off dues to the FCSPB due on under the guise of paying 27.5% to state with federal share pensioners and still rolling maize pensioners in violation of Rule 5(4) of the first defendant constitution. They stated further that the first defendant eventually ceased payment of any percentage of the check-off dues to the FCSPB up to the time of filing this suit. The first defendant's explanation of the dispute is that by the provisions of Rule 19 of the Constitution of the defendant, the check-off dues that accrued to members of the first defendant are allocated in the following manner: 25% to local branches, 30% to state sectoral council, 35% to national secretariat, and 10% to Nigeria Labour Congress. In view of this provision of the Constitution, the pure federal civil service pensioners who constitute the FCSPB were entitled to 55% of the check-off dues collected from its members, representing 25% for the local branches and 30% for the sectoral council. It was further explained that before 2018, the state sectoral unit of the first defendant was made up of state pensioners with federal share, pure federal civil service pensioners and still rolling mills. But in 2018, the pure federal civil service pensioners were carved out of the state sectoral unit, and after the carving out and based on agreement of the parties, the 55% check-off dues collected from the pure federal civil service pensioners and state pensioners with federal shares were allocated equally among them at the rate of 27.5% each, making a total of 55%. Upon paying 27.5% of the check-off dues to the pure federal civil service pensioners branch, the remaining 27.5% were paid to the state pensioners with federal shares and the still rolling mill. Later on, after getting details of the numerical strength and financial contributions of the pure federal civil service pensioners and state pensioners with federal shares from the second defendant, the first defendant started allocating 55% of the amount collected from the respective members of the pure federal civil service pensioners, state pensioners with federal shares and still rolling mills to the branches in accordance with the union constitution. The first defendant explained that the dispute arose when the claimants, who claimed to be representing the interests of the pure federal civil service pensioners, agitated that the first defendant should pay them the entire 55% check-off dues. The entire 55% of check-off dues collected from both the pure federal civil service pensioners and those of the state pensioners with federal shares and still rolling mills. It was further averred that the two units have been paid their 55% of the check-off dues collected from their respective members. The first defendant admits withholding the check-off dues of the FCSPB, but said it was done as a result of the claimant's refusal to obey the General Secretary and failure to subject themselves to financial scrutiny, which was an act of confrontation with the Union Constitution. From the evidence of the parties, it is not in dispute that check-off dues received by the first defendant are allocated in the way earlier enumerated. The claimant said the FCSPB is entitled to 55% as laid down under Rule 19(7) of the defendant's constitution because it is both a local branch and state sectoral council of the first defendant, who are respectively entitled to the 25% and 30% of the check-off dues. Sorry, please. Something is interfering with my... The first defendant admitted when it averred that, I think I have repeated some basis. Okay. From the foregoing, it is clear to me that the FCSP, being a sectoral unit or branch of the first defendant, has its local branches and sectoral council. For that reason, and in view of the provisions of Rule 19(7) of the First Defendant Constitution, the FCSPB is entitled to be paid its share of check-off dues totaling 55%, comprising 25% for its local branches and 30% for the sectoral council. The real area of dispute between the FCSPB and the first defendant has to do with the category of pensioners check-off dues from the FCSPB, from which the FCSPB should be paid 55%. It is clear to me that the members of the FCSPB are the Federal Civil Service pensioners. Thus, the percentage of dues the FCSPB is entitled to be paid is from the check-off dues from the Federal Civil Service pensioners who are members of the FCSPB. It is not also in dispute that payment of pension of the said Federal Civil Service pensioner is done by PTAD. It is PTAD who deducts check-off dues of the pensions which it remits to the first defendant. Of course, that is why the claimants joined PTAD in this suit, seeking orders to compel PTAD to remit check-off dues directly to FCSPB. The first defendant explained that as a result of the controversy in the sharing of check-off dues between the pure Federal Civil Service pensioners and state pensioners with federal shares, it sought clarification from PTAD on the numerical strength and details of the financial contributions of pure Federal Civil Service pensioners and state pensioners with federal shares remitted to it by PTAD. In a letter dated 30th June 2020, PTAD gave the clarification showing that the check-off dues it remits to the first defendant comprise of check-off dues deducted from the pension of pure Federal Civil Service pensioners, state pensioners with federal shares, and still rolling mill pensioners. The still rolling mills pensioners. The letter from PTAD is Exhibit D3. I have seen the letter. From its content, the 1% check-off dues PTAD remits to the first defendant comprise of the dues of the Federal Civil Service pensioners, state pensioners, and still rolling mill pensioners. The number of each of these categories of pensioners was stated in addition to the total amount of 1% dues remitted in respect of category of pensioners. This clarification came from PTAD in June 2020, and according to the first defendant, from then on, it has been remitting the full 55% of the check-off dues paid by members of FCSPB to FCSPB, full 55% of the check-off dues paid by state pensioners with federal shares, and full 55% of the check-off dues paid by still rolling mills pensioners to NUP, State Branch Stroke Council. The claimant did not dispute the clarification from PTAD, but I find that the basis of their insistence that the FCSPB was being paid the incomplete percentage of check-off dues is because they believed the FCSPB is entitled to 55% of the entire check-off dues from PTAD. The claimants made this an issue when they contended that state pensioners with federal shares do not constitute a branch or unit in the union, but are best categorized as part of FCSPB, and as such, the check-off dues of pensioners belong to state pensioners with federal shares should be paid to FCSPB, See paragraphs 36 and 48 of the statement of facts and paragraph 11 of the statement of the claimant's reply to the first defendant's statement of defense. I have also seen Exhibit C21, which is a letter written by FCSPB on 16th October 2018 to the first defendant. From the content of this letter, it was the position of the FCSPB that it is the one entitled to full 55% of check-off dues from pension paid by the federal government. There's also Exhibit C27A, a letter written on 19th October 2020 by FCSPB to the first defendant. The relevant content of the letter is as follows. The state pensioners with federal share were ab initio federal civil servants before the creation of states in 1976. And then, in view of the fact that the state pensioners with federal share are part and parcel of the federal pensioners, we wish to inform you that our total of 55% include both pure federal pensioners and state pensioners with federal share. In this letter, the FCSPB recognized that there are state pensioners with federal share whose check-off dues, as disclosed in Petard's letter of 30th June 2020, make up the dues remitted to the first defendant. FCSPB claimed, however, that state pensioners with federal shares are part of FCSPB and as such entitled to be paid 55% of the dues from both pure federal pensioners and state pensioners with federal shares. In cross-examination, CW1 said part of the agitation before this court is that they are entitled to be paid deductions from both pure federal pensioners and also the state stroke federal pensioners, but they do not want the contribution from still rolling mills because these are not civil servants but are from parastatals. This is the bone of contention of the claimants with respect to the claimants' allegation of payment of inaccurate check-off dues to FCSPB. Now, I have mentioned earlier that the first defendant said after the clarification from Petard, the FCSPB was being paid its 55% dues from its members categories as pure categorized as pure federal pensioners, coming to the grievance of the claimants that the FCSPB is entitled to 55% of all dues from Petard. The question to be considered is whether state pensioners with federal share or both state pensioners with federal share and still rolling mill pensioners are members of the FCSPB as to be entitled to the demanded percentages from the check-off dues of these categories of pensioners. The claimants told the court that the FCSPB is the branch of the first defendant to which all retirees from the Federal Civil Service belong. This is what is otherwise called pure federal pensioners. In cross-examination, CW1 explained the difference between members of the FCSPB and state pensioners with federal share. He said the FCSPB are those whose pension are fully paid by the federal government, while the state pensioners with federal share are those whose pension are being paid by the federal government and state government. That is, the federal government pays part and the state government pays part. That is to say, in contrast to pensioners fully paid by the federal government, state pensioners with federal share are state pensioners to retirees whose pension is partly paid by the federal government. I also find this distinction in Exhibit D3 showing that Petard pays pension to some pensioners categorized as state pensioners with federal share, different from pure federal pensioners. After considering the totality of the evidence in this suit, I find that state pensioners with federal share are different from pure federal pensioners. It is the pure federal pensioners that formed FCSPB. The state pensioners with federal share are not members of FCSPB. Accordingly, the 55% of check-off dues the FCSPB is constitutionally entitled to is restricted to check off dues of pensioners who are its members, that is the pure federal pensioners or pensioners fully paid by the federal government. Since state pensioners with federal share and pensioners of the steel rolling mills are not members of FCSPB, the FCSPB is not entitled to any share of the dues from these categories of pensioners. Although the claimants claim there is no such unit in the first defendant known as state pensioners with federal share, it is however clear that there are members of the first defendant who are categorized as state pensioners with federal share and whose check-off dues goes to the first defendant. I find that those state pensioners with federal share are not members of the FCSPB. Accordingly, FCSPB is not entitled to percentage from the dues of this category of pensioners. The dues from which the FCSPB is entitled to 55% is the dues from its members described as pure federal pensioners. According to the defendant, since the clarification from PITAD in June 2020, it started paying 55% of dues received from pure federal pensioners to FCSPB. In the claimant's reply, they did not deny being paid 55% of dues received from pure federal pensioners, but their complaint was still that what was paid to them was inaccurate for the reason that the payment ought to include dues from state pensioners with federal share. It implies that the claimants agree that FCSPB was being paid 55% of dues received from pure federal pensioners. In my view, the payment of 55% of dues received from pure federal pensioners who constitute the membership of FCSPB to FCSPB by the first defendant is in compliance with Rule 19(7) of the first defendant's constitution. Before the clarification from PITAD in June 2020, it is not in dispute that the defendant was remitting 27.5 of dues to FCSPB. The claimant's complaint about the 27.5% remittance is from the time of the inauguration of the NEC of FCSPB in 2018. The claimant said after the inauguration of the sectoral NEC of FCSPB and from the month of August 2018, it was observed that the check-off dues remitted to it by the national headquarters of the first defendant was 27.5 of the check-off dues instead of 55%. It is on this account the claimant sought reliefs 2 and 4. The first defendant admitted it was initially paying 27.5 of the check-off dues to FCSPB. Its explanation is that it remitted 55% of the dues collected from the pure federal civil service pensioners and state pensioners with federal shares. But since it did not know the numerical strength and details of the financial contributions of pure federal civil service pensioners and state pensioners with federal shares in the dues remitted to it by the second defendant, it decided to be dividing it equally among pure federal civil service pensioners and state pensioners with federal shares at the rate of 27.5% each, making a total of 55%. I have seen that it was in PITAD letter the different categories of pensioners whose check-off dues PITAD remits to first defendant was set out together with the amount each category contributes as check-off dues. Before then, PITAD merely remits the total of 1% of the check-off dues deducted from all the category and remits to the first defendant. Without the prior information to the first defendant as to the different category of pensioners whose check-off dues it receives from PITAD and the amount each category contributes as check-off dues. Without this, I cannot fault the first defendant in balancing the check-off system by apportioning the 55% check-off dues meant for sectoral council and local branches in half between the FCSPB and state pensioners with federal shares who remained under the first defendant straight-stroke sectoral council after carving out the federal civil service pensioners into FCSPB. Clearly, the check-off dues remitted in bulk by PITAD to first defendant between 2018 and 2020 comprised check-off dues from members of FCSPB and state pensioners with federal shares. Having formed a branch in 2018, the FCSPB is entitled only to a part of the 55% initially being remitted to the State Sectoral Council. The part of FCSPB from the 55% dues from PTAD as rightly shared by the first defendant is 27.5%, while the other half was meant for state pensioners with federal shares whose members check off dues is part of the dues. It is for this reason I hold at this point that the FCSPB is not entitled to its claim to be paid the other 27.5 of the check-off dues from July 2018. In Relief 5, the claimant sought an order mandating the first defendant to release the arrears of accurate percentage of 55% monthly check-off dues collected by the first defendant, but which had been withheld by the first defendant for the months of May and June 2021 and since April 2022. The facts in support of this claim are in paragraphs 61 and 65 of the Statement of Facts and paragraphs 32, 34, 36, and 38 of the reply to Statement of Defence. See also the evidence of CW1. The first defendant admitted withholding the check-off dues of the FCSPB. In cross-examination, DW1 said the last time remittance was paid to FCSPB was in April 2022. The first defendant's reason is that the claimants refused to obey the General Secretary of the Union and also failed to subject themselves to financial scrutiny. I have again examined Rule 19 of the Constitution of the Union, but I cannot find any provision therein which empowered the first defendant to withhold funds allocated to sectoral council or branches under Rule 4 and 19(7). Again, as weighty as the reason behind the withholding of check-off dues of FCSPB was, the first defendant did not say the decision to withhold the check-off dues of the FCSPB was taken by the National Delegate Conference or NEC of the first defendant. He didn't even mention which organ in the first defendant took the decision. In other words, the first defendant failed to satisfy the court that the withholding of the check-off dues of the FCSPB was done pursuant to any provision of the Union Constitution. In Relief 6, the claimant sought an order mandating the second defendant to henceforth pay check-off dues collected by it directly to the FCSPB and not through the first defendant. To establish the claim in Relief 6, CW1 told the court that there are 4 departments under the second defendant, which are Police Pension Department, Customs, Immigration and Prisons Department, Parastatals Pension Department, and the Civil Service Pension Department. He said these departments are all sectoral councils of the first defendant, like the FCSPB, which is under the Civil Service Pension Department of the second defendant. All these sectoral councils collect their check-off dues directly from the second defendant, and in turn they remit 100% of the check-off dues to the first defendant in line with Rule 4, 3, 4, and 5 of the first defendant Constitution and Code of Conduct. But in the case of the FCSPB, the second defendant pays the check-off dues directly to the first defendant, who in turn remits percentage of the check-off dues to the FCSPB. CW1 said only FCSPB's fund is being controlled by the first defendant, and this is because the second defendant fails to pay collected check-off dues directly to the FCSPB. The second defendant did not defend this suit. The implication is that the second defendant admits the averments of the claimants. Particularly, the second defendant admits that it pays 100% of the check-off dues of members of the FCSPB directly to the first defendant. On its part, the first defendant, through DW1, told the court that it is only a registered trade union that has the right to be paid check-off dues directly by the second defendant, which is 1% deduction from source by the provisions of Section 17 of the Trade Unions Act. The entire check-off dues deducted from its members, including those of the Federal Civil Service pensioners, belongs to the first defendant by virtue of Section 17 of the Trade Unions Act and by Rule 19(1) of the Constitution of the Union. DW1 also said the FCSPB is not a registered trade union, but one of the sectoral units of the first defendant, and as such, it does not have the legal capacity to operate as a trade union or to request or demand that the check-off dues be remitted to it directly. The claimants relied on Rule 4, 3, 4, and 5 of the first defendant's Constitution and Code of Conduct, which is Exhibit C20, in claiming that the second defendant should remit 100% of the deducted check-off dues to it directly. Rule 4.1 of the First Defendant Constitution and Code of Conduct provides that the rate of monthly subscription is 1% of monthly pension of every member, while Rule 4.3 provides that all branches, including sectoral units, shall remit 100% of monthly check-off dues collected to national headquarters. There is also Rule 4, Sub-Rule 4, which provides that the national secretariat shall remit back to the state through sectoral branches percentages of funds as agreed in Rule 19(7)(a) of the Constitution. The claimant's claim in Relief 6 against the second defendant is based on Rule 4.3 of the First Defendant's Constitution, but the second defendant is not a member of the First Defendant Union. Therefore, the second defendant is not bound by the provisions of the First Defendant's Constitution and cannot therefore, on the basis of a provision of the Constitution, be ordered to remit 100% of monthly check-off dues deducted from pension of members of the first defendant to a branch of the first defendant. Let me mention also that the provision of Rule 4.3 of the First Defendant's Constitution is directed to branches or sectoral units of the first defendant who directly receive check-off dues of members of the first defendant. The provision did not lay down a directive that all check-off dues be paid to the union through branches or sectoral units. In any event, the payment of check-off dues to trade unions is statutorily provided. Section 17 of the Trade Unions Act provides thus: upon the registration and recognition of any of the trade unions specified in the third schedule to this act, the employer shall make deduction from the wages of every worker who is a member of any of the trade unions for the purpose of paying contributions to the trade union so registered, and remit such deductions to the registered office of the trade union within a reasonable period, or such period as may be prescribed from time to time by the registrar. By this provision of the Trade Unions Act, it is only a registered trade union that is entitled to receive check-off dues or contributions deducted by an employer from the wages or pension of members of the trade union. Again, the provision clearly states that the remittance of the check-off dues is made directly to the registered office of the trade union. The FCSPB is not a registered trade union. It is rather a branch of the first defendant, which is a registered trade union. In view of the provisions of Section 17 of the Trade Unions Act, it is the first defendant who is statutorily entitled to receive the check-off dues deducted by the second defendant from the pension of members of the first defendant. Thus, by Section 17 of the Trade Unions Act, the second defendant is authorized to remit check-off dues or contributions directly to the first defendant, union. The claimants have mentioned instances where the second defendant remits check-off dues directly to some member branches or sectoral units. The claimants did not furnish this court with evidence of such direct remittances by the second defendant to such branches or sectoral units, but this court is entitled to believe that the allegation is true in view of the failure of the second defendant to controvert the allegation. Even at that, can the fact that the second defendant remit check-off dues directly to some branches or sectoral units of the first defendant entitle the FCSPB to claim for an order mandating the second defendant to likewise pay directly to it? I think not. Section 17 of the Trade Union Act is the guiding provision on deduction and remittance of check-off dues. It does not support direct remittance of check-off dues to any branch or unit of a trade union other than the registered trade union itself. In view of the foregoing, the second defendant is not under any obligation to pay all or any part of the check-off dues deducted from the pension of members of the first defendant to the FCSPB directly. Its obligation in Section 17 of the Trade Unions Act is to pay the check-off dues deducted from the pension of members of the first defendant directly to the first defendant. Accordingly, I hold that the claimants failed to prove Release 6 sought by them. There are also reliefs 3 and 8 of the complaint. There are also reliefs 3 and 8 of the complaint. Reliefs 3 and 8 of the complaint, which the claim where the claimant sought claims touching on the dissolution of the neck of the FCSPB. The claim in relief 3 is for a declaration that the dissolution of the neck of FCSPB on the 21st of April 2021 and the appointment of a caretaker committee for the FCSPB on 22nd April 2021 by the NEC and National Delegates Conference is illegal, null and void, and unconstitutional, and in violation of the due process laid down in the first defendant's constitution and code of conduct. In relief 8, the claimant sought a perpetual order restraining the first defendant from harassing, intimidating, preempting, molesting, dissolving, or interfering with the lawful activities of the NEC of FCSPB till their tenure runs out in July 2022. The grievances of the claimants on the basis of which they sought these claims are that the election into the sectoral neck of FCSPB took place on 18 July 2018. In that election, the first and third claimants were elected as the national chairman and national treasurer of the FCSPB. On his part, the second claimant was employed as national secretary of the FCSPB. The claimants also said because of the agitation of the FCSPB for payment of arrears of its accurate percentage of check-off dues, the first defendant resorted to harassment and intimidation of the claimants, who constitute principal officers of the NEC of FCSPB. The first defendant proceeded to dissolve the NEC of the FCSPB at the first defendant's NEC meeting of 21st April 2021, and the dissolution was ratified by the National Delegates Conference on 22nd April 2021. The first defendant proceeded to appoint an 8-man caretaker committee for the FCSPB and issued letters dated 29th April 2021 and to the first and second claimants, informing them of the dissolution of the sectoral neck of FCSPB. The claimant said the dissolution was done in breach of the claimant's right to fair hearing, but the first defendant later complied with the directive of the Federal Ministry of Labour and Employment and reinstated the sectoral neck of the FCSPB in a letter dated 15 July 2021. In its defence, the first defendant averred that when the neck of FCSPB was inaugurated in April 2018, the first to third claimants refused to subject themselves to the authority of the first defendant and willfully disobeyed lawful instructions from the organs of the first defendant. As a result, the conduct of the claimants was reported to the National Administrative Council of the first defendant, and the committee recommended the dissolution of the NEC of FCSPB and appointment of a caretaker committee. This recommendation was referred to the Central Working Committee of the Union, which ratified the recommendation before the recommendation was presented before the National Delegates Conference of the Union, who approved the dissolution of the NEC of the FCSPB at the National Delegates Conference held on 22nd April 2021 at Abuja, and therefore thereafter appointed a caretaker committee for the FCSPB. However, as a result of the intervention of the Ministry of Labour and Employment and the Nigeria Labour Congress, the NEC of the first defendant rescinded the dissolution of the NEC of FCSPB and reinstated the NEC. After the reinstatement, the NEC of FCSPB served their 4-year term, which ended on 19 July 2022. From the evidence of the parties, it is clear that the claimants constituted the NEC of the FCSPB, which was inaugurated on July 18, 2018. It is also not in dispute that the NEC of FCSPB was dissolved by the first defendant in April 2021 and a caretaker committee appointed. It is also not in dispute that the dissolved NEC was reinstated by the first defendant on 15 July 2022, and the tenure of their tenure expired on 18 July 2022. This suit was filed on 19 July 2022. That is to say, the NEC of FCSPB had been reinstated before this suit was filed. In other words, the dissolution of the NEC of FCSPB had been overtaken by the event of its reinstatement before the date this suit was filed. Now, I find from the evidence that the NEC of FCSPB was elected on 18 July 2018 for a 4-year tenure CW1 said in his evidence in chief that the neck of the FCSPB was inaugurated on 18 July 2018 to run for 4 years, and the tenure should have terminated on 18 July 2022. In cross-examination, CW1 said the exco of his branch were elected on 18 July 2022 for a period of 4 years. The 4 years period lapsed on 18 July 2022. In his cross-examination too, CW2 said he was elected chairman of his branch on 18 July 2018 for 4 years term, which lapsed on 18 July 2022. On the basis of these facts, the first defendant contended that the NEC of SPSB, which was inaugurated on 18 July 2018, ceased to exist with effect from 18 July 2022 by virtue of Rule 12B of the first defendant's constitution. From the evidence, the tenure of the NEC of the FCSPB, in which the first to third claimants were officials, was 4 years from 18 July 2018 and shall stand dissolved after 4 years. See Rule 14 X1X in Roman figures of the Union Constitution. The tenure of the claimants lapsed on 18 July 2022. By effluxion of time, the NEC of FCSPB, elected on 18 July 2018, dissolved automatically on 18 July 2022. I've heard CW1 and CW2 claim that until elections are conducted into the NEC of FCSPB and proper handover is done by the outgoing NEC of the FCSPB to the incoming NEC, the NEC of the FCSPB constituted by the claimants will continue to manage the affairs of the FCSPB. By this evidence, the claimants made it clear that they have extended their tenure to the time a new NEC of FCSPB will be elected. This is contrary to Rule 14 X1X of the Union Constitution, and it portrays the claimants as constituting or equating the FCSPB to a parallel union to the first defendant. In my view, the 4-year tenure of the NEC of FCSPB cannot be extended unilaterally or at the whims of the claimants because new election has not been conducted. The fact which the claimants must come to terms with is that the tenure of the NEC of the FCSPB, inaugurated on 18 July in reliefs 3 and 8 relate to the tenure of the NEC of FCSPB that has lapsed before the institution of this suit. Extended by this court. Therefore, to determine whether the dissolution was right or wrong will not throw any benefit on the claimants. An action or a claim in an action where there is no live matter in it to be adjudicated upon, or when its determination holds no practical or tangible value or any right or benefit on the successful party, the action or claim is said to become an academic issue. See Adekunle versus AG Ogun State 2018. Ado against INEC 2017. The issue raised by the claimants with respect to the dissolution of NEC of FCSPB cannot benefit the claimants in any way because they are no longer NEC of FCSPB since 18 July 2022 by the expiration of their tenure. In addition, as at the date of the judgment, the claimants are no longer NEC members of FCSPB. Thus, they do not hold positions in the NEC which they seek to protect by the perpetual injunction they sought in Relief 8. The result is that the claimants are not entitled to Relief 3 and 8 sought in the complaint. The claimants also seek payment of the sum of 20 million naira in Relief 11, which is said to be special damages incurred as solicitors' fee for the prosecution of this suit. The claim being a claim for recovery of solicitors' fee is not proved. The claimants did not prove that they paid fee of the amount to their solicitor. The claim is not justified and it lacks merit. To conclude this judgment, I find that the claimant succeeds in part in their claims. Reliefs 2, 3, 4, 6, 8, 9, 10, and 11 fail and they are hereby dismissed. Reliefs 1, 5 and 7 succeed, and they are granted in these terms. 1. It is declared that the FCSPB is entitled to be paid 55% of the monthly check-off dues of its members who are the pure federal pensioners collected by the first defendant under the check-off system pursuant to Rule 19(7) of the First Defendants Constitution and Code of Conduct. 2. An order is made directing the first defendant to immediately release accurate percentage of 55% of monthly check-off dues of members of the FCSPB collected by the first defendant, but which had been withheld by the first defendant for the months of May and June 2021 and since April 2022. 3. An order is made perpetually restraining the first defendant from further withholding the constitutional and accurate percentage of 55% of monthly check-off dues due to the FCSPB. Parties shall bear their respective costs. Judgment is entered accordingly. Yes, so I think your microphones are muted.
Yes, my lord. Thank you, my lord. Yeah, my lord, we are most grateful for the well-considered judgment of the courts. May God Almighty continue to strengthen us. But my lord, be that as it may, we don't know if we'll be able to get a copy of the judgment to apply by tomorrow at 5 should be ready, my lord.
Yes, definitely. If you do not get it today, you'll get it tomorrow. Because it's quite a mouthful, if you ask me. It has sapped all my energy. So
I can see.
I know that you will need to settle down to study the judgment in order to determine the way forward.
Yes, madam. Yes,
I am not unmindful of that. The judgment is ready. That's why sometimes you heard me pausing. I was correcting the relevant mistakes while reading because I read directly from my system. So I'm going to immediately get them printed now and get them signed. They should be able to get to you today or tomorrow at the latest.
My lord, we are very grateful.
Thank you very much.
All grace to my lord Sebo.
Thank you. Do have a nice day.
Thank you, madam.
Thank you, madam.
Thank you.
Yes, madam.
Okay. That is my big man that we are using now.
Mo ti leave o.